We're very grateful to your lordships for sitting early on a Friday to deal with the directions in this matter.
Yes.
As I hope your lordships know, I appear for the plan company with my own friend Mr. Shaw. Mr. Alatar to my right appears for the Class A supporting creditors. Mr. Phillips appears with Mr. Abraham, Mr. Mustafa for the Class Bs, Mr. Thornton for a subordinated creditor TWL, and Mr. Day appears for Mr. Maynard MP. Well, I think, you know, this is actually not my appeal as the plan company, but we are seeking that the appellant's appeal be expedited. Although we're successful at first instance, we need to preserve the value of that appeal in order to implement the plan, essentially before the plan company reaches the end of its liquidity runway. Well, this is not an appeal that can in a sense be heard in a sort of usual course, because the liquidity, as I'm going to explain, and as we set out in our evidence, the liquidity runway is very tight. So what I propose to do is explain why we have the urgency.
Well, I think we understand there's some urgency, but as the judge said, you could have started all this earlier. And then you wouldn't have put the court under pressure in the way that has been deprecated in Adler, but ignored apparently by the parties in this case.
Well, I respectfully admit that's not quite right. When one looks at the timetable, and you can actually see from the judge's judgment, from various paragraphs...
Why did the judge say it then? Is that part appealed?
Well, I mean, what he said was, in a sense, he hadn't had an explanation in the sense that people were standing up at the hearing going into archaeology as to exactly why they were there. But that's because once you're at the trial of the sanction hearing, you're forward-looking. In a sense, the history is archaeology.
No, that wasn't the point he was making at all, Mr. Minister. The point he was making was he'd asked for an explanation for why it was that everybody was coming along at the end of December and not months earlier, because everybody's known that this was coming down the road for months.
Well,
the problems with Thames Water have been all over the newspapers for months and months and months. And that was the point he was making. And he says, in terms, I didn't have a satisfactory answer to the question of why this had all been left so late. Nothing to do with the archaeology.
Well, no, but if one steps back, one can see from the very facts and the sequence of events that the judge set out in his judgment why we ended up with a plan on the 10th of December. What we say can't be said is that there's an obvious moment at some point earlier where the plan that came before the court could have been presented, because it's not...
Lemestre, the judge said, I was never given a satisfactory explanation why no application was made to court before December 2024, or so little time built into the timetable for the court to consider its decision. And he reminded the parties of the guidance which Lord Justice Snowden had given in Adler at paragraph 65, which I urge all those present to read and read carefully, because the court is not here to be bounced into hearings by parties who don't arrange their affairs in proper order. And that is what is sticking in my craw at the moment, Mr. Lemestre, when we're being told there is some apparent cut-off point, which if you look at the cash flow forecast doesn't arise until the middle of April, really. And we have to have a hearing, which may not be a just hearing if it's heard starting on Monday. Can you start the appeal on Monday, and can everybody get a just hearing? I don't know.
No, well, I think we accept that the hearing is not going to be on Monday.
Well,
but we do
the
say...
court may only be able to do Monday, Mr. Lemestre. It's not for you to dictate when this court sits.
I understand entirely, my lord. What I want to do is simply set out where we are and explain the way the timeline works. I understand and accept that we're entirely in the hands of the court, my lord, and we're asking...
Have you spoken to your colleagues and worked out when this appeal can be fairly tried in the interests of justice, so that a proper decision can be reached on the matters for which permission to appeal has been given by the judge?
Well, we say, well, Mr. Day's timetable, which involves skeletons next week and the hearing the week after, we say that can result in a just hearing, if the court can sit then.
That's the week after is the week of the 3rd of March?
Yes, my lord.
That's the court is not able to sit on the 3rd of March. So the options here are either the 10th of March or probably next week.
Well, I mean, what I was going to explain to you was the urgency and the way the liquidity runway...
I mean, we have other business in this court. We have really important appeals by people who have looked after their own affairs.
Understandable. I think it's important that I do explain how we've got to the 10th of December. I see exactly what the judge said, but when one actually looks at what the steps in the judgment, one can see what was going on.
We've read everything. We understand all these points, but then what it comes to, what my lord's saying to you is that we could convene a court for next week, which seems to me to be too soon for all sorts of reasons, or we can give you a court on the 11th, 12th and 13th of March. And if the reality is that everybody has agreed that next week is to really not just, as my lord said, then it's going to have to be 11th, 12th and 13th of March, and you're just going to have to arrange your respective affairs accordingly.
Yes. You're getting, a lot of money is being taken out of this company. This is a very expensive refunding, very valuable to those investing in it, 9.8% coupon. And what were the costs? £800 million for an input of 1.6 billion? I mean, that's extraordinary. This is very valuable to somebody, and I find it very, very hard to believe that this cliff edge is going to be really reality because we sit on the 10th of March.
Well, I mean, the reality of the cliff edge is that my client's the plan company. There are directors who sit there seeing the liquidity runway coming to an end. They're human beings. They have to sit in board meetings and manage the liquidity and decide what to do. In a sense, they cannot simply hope that the plan will, they will maintain the sanction that they've got. They've put forward a plan.
Thought of that.
Well, but your lordships have to understand the timing. It was the Ofwat determination in July last year that really kicked this off. And the process is not simply, as at July, you can present a plan, as we did in December. In the intervening period, there's incredibly important steps, which is the negotiation and what are called the STID proposals in the judge's judgment, which allow the plan to be presented without that itself being an event of default, and which released some of the trapped cash to extend the liquidity runway from December to March. So if there had been a plan coming forward in September, it would have been to deal with a liquidity runway ending in December. I mean, this is an incredibly complicated business, an incredibly complex business.
It's very complicated, and we're not arguing the appeal now.
No, exactly. But when
we're looking at a cash flow forecast, which is what is really important. And the question for you is, can the company manage to find a solution which will keep it alive if the appeal were heard in the week of the 10th of March, or not? Because if not, we have to hear argument from these other parties as to why, for very good reason it seems to me, they probably can't be ready next week.
Well, as I say, my clients will seek to manage their affairs. If the appeal is heard in that week of the 10th of March, they will have to manage their affairs, and then in their board meetings they'll have to consider the realities and whether or not they can wait, but that, on a day-by-day basis. But they will, we're in your lordship's hands.
Some of the creditors may have to consider their position.
Yes, well, I mean, we understand that more, what I can't say is that the longer that it goes on, the directors will inevitably have said, we will wait. At some point, there may come a point where they say we can't wait.
As long as we're not, I would have thought that anybody who practices in these courts knows that to come to the Court of Appeal and ask for a 2, possibly 3-day hearing the following day in front of specialist judges, this doesn't require any judge who has no experience of schemes of arrangement. You know that, I know that. We've got to convene a court of specialist judges, and to ask for that to happen on a particular day because affairs have not been put in order so that there is a window that the court can accommodate itself to is frankly ridiculous.
Well,
and what you've got to do now, I suggest, maybe we'll take a moment and adjourn, and people can breathe deeply, and you can talk to your colleagues and see if you can agree that the 10th of March is the Monday, the 10th of March.
Yeah, we do it on the Tuesday.
Do it on the Tuesday, 11th, 12th and 13th of March. Is that a possible option? Is that an option that finds favour? The 3rd of March is simply not possible. I cannot convene a court with the right judges in it. I'm sorry. And so it's either next week or the week after. And that is really moving heaven and earth for your company and this plan. Now, if that doesn't work, then the choice is between that and you'll have to take your chances, or next week. So what I suggest is that with that information, we take, shall we say, 10 minutes?
Oh,
and you see what you want to invite me to do. And if you don't agree, I will decide. We will decide.
We will
Well,
All right?
yes, ma'am.
Okay, well, we'll reconvene at 10 to 10.
Also, it's efficient. You've not seen that. Some of us write quickly, right? Some of us got lives to lead.
Some of us haven't got lives, let any more. And shall I mention the points? Because that's what he meant.
This is to do it next week.
David, just leave it to us. We're dealing with the process.
We're producing that 3 hours.
You're not responsible for this. We need to get on with that.
You have placeholders. Some people cannot do.
Okay, so I'm not sorely in absence of this course. It's industrious.
Normally we have the same.
You might want to Listen, mate, I'm so tired. Jokes. I just can't.
That's not wrong. Guess what? That's what you did to me. Well, it should be the Friday. Exactly what we're free to do. I mean, that's yeah. Well, I don't think.
Yours in.
Okay, let me have a look at the map. Let's just have a look at the map. Andrew, you've got my
We might be able to give it 10 a.m. He'll give us a. We need to take a week. Look, we've got food. No, but you might get some early. You might get some more early. You'll get some early. Yeah, that's what he's saying. We'll days. So we'll get that. That's perfectly fine.
Flexible enough.
We'll argue about that.
Yeah. No, it might be. Everyone can see that. Yeah, you go. No, he said you can do 3 more days. We'll say he'll do his on the Friday.
Oh, six.
That's
So,
what it was.
can I just get, so you guys are proposing to do yours on the Friday? You guys are going to do yours on the Friday?
Well, I'd rather that we were all just at once. But if it breaks the impasse, I'll go to that first. We need the weekend.
Yeah, so do I.
Third to Dick.
And now Mr. Boss defends.
So I'm in court that Friday, so I would probably prefer. I could do it on Saturday. I'd rather agree to it.
Yeah, I know. Okay. So, Maestro,
Yeah.
Yes.
we are going to for 10 a.m. on Monday. So you can do with the weekend. And then that gives you between the third
Right, that's 3.5 days, I guess. We've got 3 skeletons, we've got 25 pages for it.
25 pages, you're kidding me.
What you need to ask me.
Of course I will, I'll write to him. So
Then we get 3
Mark.
Now it is.
Well, we can say Friday the 28th. You can say 10 on the 1st. They can decide.
but apart from that, the other stuff,
Yeah, if they can do, let's not do.
I'm really not
No.
It's not my style.
We need to deal with the
We do not. We can't hearings now. Reading 7 and 10. Our scope on the 6th. There's 10 a.m. on the 3rd. We're saying 4 p.m. But then we can do it no.
So, Andrew,
Know that they pay marketing.
Andrew?
Yeah.
So you'll explain that that's where we are, so we're saying the third and the okay, that's really lovely.
We've only got 2 rounds. It means more for us, because
We can't have 20 pages, we can't have 3. I know. Yeah, I understand. I mean,
Well, yeah.
5 minutes.
Which is why. He gets it. But
No, I know.
they're really worried that they might have to Yes, Mr. Phillips.
Well, I've taken instructions and I've discussed matters with my own friends. We are in a position where we accept that realistically there's not going to be a hearing next week, and therefore we've sought to agree a way to get to a hearing on the 11th and 13th of
On the
11th to
11th.
13th.
And is it 2 or 3 days?
Well, we think 3 days should be allowed. We'd hope
3
it
days
could be
should
dealt
be.
with quicker, but I don't want to say 2 days and risk spillover. There is some overlap, for example, between the grounds of appeal of TWL and Class B, but it's not entirely clear at the moment quite what that overlap is.
Yes.
So there's things like that that may shorten the hearing, but we can't say at the moment that it will definitely be 2 days.
And you know, I should say the court will do its best to get a decision immediately or shortly after the hearing, but that cannot be guaranteed depending on the argument and the court agreeing and so on. So obviously we'll do our best, and we're conscious that obviously the parties would probably all want the outcome, even if not a judgment or judgments, as soon as could be obtained.
Yes, Maud. I mean, there's a particular reason for that. Your Lordships will have seen that the plan is partially implemented, so in a sense maturity dates have gone out on a sort of conditional way that may be unwound if the appeal goes against the plan company. And obviously, the sooner that is known and the steps are unwound, the clearer it becomes the legal position that everyone is in. At the moment, there's a sort of conditional extension, and that's not an extension which we'd hope would last conditionally. It needs to be sorted out, fixed one way or the other. So it affects all the creditors in that sense.
Do we need to give directions for skeletons?
Well, we were the tentative timetable that's been suggested. There's one disagreement. Is this? Skeleton arguments from the appellants, either we say on 4 p.m. on the 28th, that's a week today, 28th of February. They're going to say 10 a.m. on Monday the 3rd of March to allow the weekend.
Yes.
Us to respond and the Class A respondents to respond 4 p.m. on the 6th of February. March.
Yes.
And then the bundles will be finalised and lodged by the 7th, on the 7th.
Right.
Ready for the hearing on the 11th to the 13th.
You say, yes, Friday the 28th. Okay,
Yeah.
let's hear why they
Well,
say not.
Can I just say, the reason we say is obviously we're responding to 3 skeletons. They're each producing one, we would hope 25-page skeleton each. We've got 3 separate skeletons to respond to: public interest from Mr. Maynard, valuation and fairness from the Class Bs, and different fairness points from TWL. So we're having to respond to all 3 of those. And that's why we say with the extra time, making them go by the 28th.
You've got quite a few lawyers, right?
Yes, Mark. But I mean, in a sense, the skeleton argument have to be a coherent whole
No,
for
no.
Mr. Smith to advance
I
the
was
case.
only pulling your leg, Mr. Yes, who would like to? Yes, Mr. Phillips.
Yes, my lord, my lords. We would ask for 10 a.m. on the Monday, in part because we represent an ad hoc group of creditors, and there are quite a few clients that we need to make sure have seen skeletons before they come in. But the other reason is the history so far. It's not just that there is that unexplained delay between the 24th of October and the 10th of December, but it's everything that's happened since. And on each occasion, I have said to the court, this is too tight, it's too difficult, and I have been proved right, regrettably. Just so that your lordships know, we were served with the first witness statement from the CFO on the 24th of January, 11 days before I had to cross-examine him. We were served with an expert witness statement by Mr. Weera Singh, which dealt with what's called the final determination on the 24th of January, and I had to cross-examine him. I had to cross-examine him 12 days later. And so we made an application to Mr. Justice Leech in which we asked if we could use the 4 days for the evidence and then perhaps come back for 2 days of closings the following week. That was strongly opposed and I failed. And so I had to, for example, I had to cross-examine...
Does the archaeology really matter to the
well,
time summons question of whether it's Friday or Monday?
Yeah.
The point you're really making is you want till 10 a.m. on the Monday because you need more time to...
Yes.
Mr. de Maistre is allowing you for. That's as simple as that, isn't it?
It is as simple as that, my lords.
Yeah.
And
it doesn't really help. You can say, "Oh well, I've done this before and I was right." Well, I suppose it helps up to a point.
My lords, you're absolutely right. But I've got a very painful history of this so far, and I would very much like time so that I can help your lordships with a proper skeleton that we've had time to think about, and that we can articulate it properly, and then we can have a proper trial the week in the following week. And I would respectfully submit that 10 a.m. Monday, that gives my learned friend until 4 p.m. Thursday, and that's enough time.
To what extent does the extra 3 days enable you to coordinate with your other appellants?
My lord, I'm sure that is something we can do. It is something we found very difficult so far. But my lord, your lordship's absolutely right, especially between us and TWL. We've seen the grounds, there are similarities, and the one thing that your lordships will not appreciate is if we're doubling up. Absolutely.
Can we have an informal assurance from all of you that you will do your best not to double up, to have one lead advocate for each point, and will take any extra time we allow you for that purpose?
Yes, my lord. Certainly. Yes, my learned friends are nodding. We will do that, my lord.
Yeah. Reluctant to get to their feet, but happy to nod.
Happy to nod, my lord.
Very good. Do you want to say anything else, Mr.
No, not on the time. It's simply the fact that we have...
You say you. 10 o'clock on Monday.
Thank you, my lords.
That's the first time in a long time. When I accepted appointment as Master of the Rolls, I didn't realise I would be dealing with time summonses on Friday morning.
Well, I mean, there may be a question about page limits now, which is...
Page limits, 25 pages. 25 pages for them, for sure.
Yes, more. Well, I mean, Mr. Phillips suggested to me that he might want more. So...
Who says he wants more, Mr. Phillips?
My lords, I don't know. I really don't know. The position is we had a 179-page judgment a few days ago. We've turned around grounds of appeal in record, well, it probably isn't record time, but in a very short time, and we simply have not got to the point. But I hear your lordships, and I know the rules.
I want them to be 25 pages. You can make specific application to Lord Justice Zacaroli if you will be handling interim matters. If you really, really need more. But I would much appreciate it if you didn't. You will realise there's a law of diminishing returns in ridiculously long skeletons.
Absolutely, my lords. Yeah. Absolutely.
Yeah. It applies to all of you, but I think actually the other side might have a better case for a little bit longer because they have to deal with 3 separate.
I mean, yes, well, that's the question. In theory, we have 3 completely separate skeletons if the grounds are all separate. So it'd be 3 lots of 25 pages. But we are not. We will.
But still,
what your lordship said, and we're going to do it as concisely as we can.
You can make the application to Lord Justice Zacaroli when you see what you face. Good. Any other points? Bundles then by, as you say, 7th of March, 4 p.m. Appellant skeletons by 4 p.m. on Monday, the 3rd of March.
10 a.m., my lord.
Sorry, 10 p.m. 10 a.m. Monday, the 3rd of March, and respondents to respond then, I suppose, by
4 p.m. on the 6th.
4 p.m. on the 6th, my lord.
4 p.m. on the 6th. Very good. Any other points?
No.
Okay. Well, thank you very much.
Thank you, my lord.
What, 5 days?